Hi, I'm Susan Grissom with Grissom Law Firm in Johns Creek, Georgia. I'm an attorney licensed to practice law in Georgia, and my practice focuses in the area of estate planning, uncontested probate, and small business law. Today, I'm going to talk about what are revocable living trusts, or RLTs. I want to start with a basic description. A revocable living trust is an instrument that's a part of estate planning that can hold your assets during your lifetime. By its nature, it's revocable, meaning you can change it during your lifetime. So as long as you are living and have capacity, you can change who the beneficiaries are, how they receive their assets, and who's going to manage those assets. Additionally, because it's a revocable trust, it typically is going to use your Social Security number, which means it won't have its own tax return. It's typically referred to as a grantor trust, and during your lifetime, it will remain in this state. Only after your death does it need its own tax ID. A couple of other things about this revocable trust. You're going to name trustees. In most revocable trusts, you'll remain that trustee during your lifetime and during your capacity. And then you'll designate people who will serve in that trustee, which is the role that manages your trust assets upon your incapacity and upon your death. You can name numerous backup trustees, or you can name co-trustees if you have concerns that your designated trustees may need assistance or may need to work together to settle your estate. You're also going to name beneficiaries of your assets in this trust. That means you're going to say who receives your assets once you pass, as well as how they receive them. Do you want them to receive them outright and free of trust when you pass? Do you have minors? Perhaps your assets need to be held in trust for them until they're older and more mature. Perhaps you have someone who has issues which would not make them in a position to manage their own finances, and so we might hold those in trust for their lifetime. Or maybe you have someone with a mental or physical disability, and perhaps we need to hold those assets in a trust that's designated as a special needs or supplemental needs trust to protect Medicaid benefits, or to protect them from themselves in some instances because they might not make wise decisions. In these instances, we work through the process to determine how and when your beneficiary should receive their assets, and then your trust would be designed with these needs in mind and with rules that designate how the trustee would actually distribute, when they would distribute, and under what terms they would distribute. In addition to this, a revocable living trust can also provide for you during your incapacity. What I mean by this is, if you're no longer able to manage your own assets, assets that are in this trust can be managed by that successor trustee. They'll have the opportunity then to sell those assets if needed to provide for your care. If you're no longer able to remain in your home, your trustee could then sell that home and take those proceeds and either invest in a different home that's more suited to your current state, or use them to rent a place for you or provide for other care that you might need. They would be able to do this without the need to go to a probate court to obtain conservatorship and permission to sell those assets, so that it would be much more smooth and effective for you without the need to have any sort of court intervention in the process. Revocable living trusts are the part of many estate plans that we prepare in our office, because we find not only that they provide for ease and efficiency, but they also provide for privacy. Because these assets then don't go through a probate, there's no need to file the trust in a probate court, which could allow others access to it as a result of being a part of the public record. Many of our clients desire this sort of privacy. Additionally, the ease and efficiency of settlement comes because without the need to go into court, we have a shorter wait time. Once you have your death certificate, you're able to begin settling the estates so that your family can actually list your home for sale. They don't have to wait, and they're able to sell the property as soon as they are ready. They can also access any assets that are inside the trust with that death certificate. They go to the financial institutions and they're able to reach out and get those assets much more quickly and efficiency. These are just a few of the ways that we use revocable trusts in estate planning. If you're more interested in more information, give us a call and we'll be happy to help.